So the highest court in the land is adopting its first ever code of conduct after a series of damning revelations about undisclosed gifts and luxury trips heightened public scrutiny of a historically scrutiny-free Supreme Court. Among those getting the closer look, Justice Clarence Thomas, whose hobbies include cozying up to billionaire GOP donor Harlan Crow and driving a debt-free RV financed by a close friend. Now, let's be clear. Most, if not all, of these rules outlined in this new code are not new or novel. They require the justices to, quote, uphold the integrity and independence of the judiciary and to, quote, avoid impropriety and the appearance of impropriety in all activities. There are those, including me, who don't think that these rules go far enough. Senator Dick Durbin, chair of the Senate Judiciary Committee, said the actions were important steps, but they fall short of what we should expect and, in my opinion, what we deserve. It's also unclear how the court intends to actually enforce these new rules, meaning at this point, the justices will essentially operate on a pinky promise, and we're left hoping for the best. Joining me now, Dahlia Lithwick, legal correspondent for Slate, the host of the podcast Amicus, and an MSNBC law and politics analyst. Dahlia, my friend, good to see you. Look, I don't buy this at all. I think it's a gratuitous move. And, you know, the real tell, I think, Dahlia, there's no enforcement mechanism, none whatsoever. And so for me, it's like, take it and at this point, right? I mean, what are we doing with this?
It's essentially a stack of pre-existing rules and statutes and canons. If you remember, Katie, last April, when the court was under the same tremendous amount of pressure to do something about its completely lack of ethics rule, they pulled out this same stack and they said, here, this is all the stuff we adhere to, and they all signed it. This is no different from that. This is the same move. It's just kind of cut and paste in a different document, and it comes with a little preamble that, and here's the tell for me, starts with the proposition that the absence of the code, they write, quote, has led in recent years to the misunderstanding that justices of the court, unlike other jurists, regard themselves as unrestricted. And then it goes on to say, that's because you're confused, American public. We were never confused. We have this stack of rules that we promise you, pinky promise, we adhere to, but because you're confused about the rules, here they are again. And so I completely agree with you. This feels like new bottles, and it also feels like an attempt to gaslight us into saying like, oh, maybe these rules are binding and we were just confused. And that's just insulting.
I'm so glad you said gaslighting, because that's exactly what's going on here. The Senate Judiciary Committee was supposed to vote on subpoenas to people like Harlan Crow and other, people that are financing lifestyles, apparently, of the rich and famous on SCOTUS. But that vote was postponed. Do you think the introduction of this 9-0 voted upon code of conduct is actually going to have a chilling effect on any moves by Congress? I mean, I will give flowers to Sheldon Whitehouse, Hank Johnson, and others who are doggedly trying to make sure that we are protected as Americans. But do you think there's going to be some chilling effect now that this code of conduct is in place from congressional investigations and other things?
I think it's fair to say, Katie, that was the intent. The reason this came out just a few short days after those subpoenas were supposed to be voted on is because the hope was that it would chill the effort. But we've heard from Dick Durbin and Senator Whitehouse and others, they have no intention of pumping the brakes for exactly the reason that we know about these ethics violations, not because the court has been forthcoming. In fact, a lot of the justices who were caught out in the reporting by ProPublica and Politico and the Washington Post still haven't disclosed things that they did that they should have disclosed. So the only thing that works is pressure from journalism and pressure from the public and pressure from the Congress. So to me, the fact that the court was willing to say, and this is a significant thing for the first time in history, wow, people are really mad at us. We should do a thing, even if it's fundamentally a toothless thing, is all the more reason to press on and say we would really like to hear what Harlan Crow and Leonard Leo have to say about why it is that some justices get flown on salmon fishing trips with people who have cases before the court. That issue has not gone away. And let's be really clear, there's nothing in this code that precludes those trips in the future.
You know, Dahlia, one ethical stopgap that we always look to as lawyers when we're looking at judges are the ability for them to recuse themselves when they know that there's going to be an appearance of impropriety, let alone actual impropriety that's going to take place. This new code of conduct, I want my viewers to understand, it talks about recusal in very obvious terms. You shouldn't be presiding over a case where there's a beneficial interest to you or a loved one or a family member, but it doesn't actually provide for a recusal mechanism. And then it at the same time says, Dahlia, but be careful, Supreme Court justices, because there's only 9 of us and there's no one above us other than God, apparently. And so you really shouldn't be recusing yourself because we can't replace you.
Yeah, I can't say it any better than you just did. First and foremost, it's nice to say that the same justices who got to make up their own minds about recusal and didn't have to explain why and didn't have to tell us when they failed to recuse. And let's remember, Clarence Thomas failed to recuse in a case in which his own wife, Ginny Thomas, had a material interest in the outcome. That hasn't changed. Clarence Thomas still gets to be the arbiter of whether he has to recuse. But then there's a huge thumb on the scale, as you know, that says, now, there's only 9 of us, and people are going to be pushing for us to recuse, and that's fundamentally political. So overwhelmingly, err on the side of not recusing so that we don't have 4-4 splits. And so the minute you've created a presumption against recusal, all of the recusal rules in the world, even if they were clear, and as you say, they are not clear here, go away because the presumption will always be, well, there's only 9 of us, I guess I have to stick around.
Dahlia Lithwick, as always, this spectacular analysis. I love it. Thanks for being here this morning. I appreciate it.
Thanks, Katie.